that work at the Women's Center and Shelter. And then my fellow co-host is also part of the team, and I'm going to have her introduce herself as well.
Thank you, Bunny. Hi, everyone. My name is Sing. I am a specialty legal advocate from Women's Center and Shelter Legal Advocacy Department. And also, I am a member of the REAL team. And thank you all for joining us. I hope you will learn a little bit from our webinars. And if you have any questions, feel free to type in the chat as Bunny mentioned. And after the webinar, feel free to reach out. Thank you.
Thanks, Sing. I also didn't say my title. I am a bilingual direct service advocate. I work at the shelter hotline. So I work within the shelter upstairs on our 3rd floor of the agency. So I'm going to pass the mic to Sarah. Sarah is our specialty real attorney, and she's going to be talking about how to help domestic violence victims in the court.
Hi, everyone. Thank you so much for joining us. I realize that the title of our webinar today is Criminal and Civil Justice with IPV Survivors, IPV standing for Intimate Partner Violence. I've modified the title slightly only because I often tell clients that on the civil side, at least with family court, this isn't where they're likely to find justice. Some of the things that we'll be talking about today, such as protection from abuse orders, go more towards safety. So I'm talking about help for victims or survivors of domestic violence in the Pennsylvania state court system. I have my email address here. Please feel free to ask questions. I'll be completely honest. I've been here for 2 years, and my work with the Civil Law Project at the Women's Center and Shelter focuses on family court matters. So in terms of other civil proceedings or even the criminal law side, I'm going to give an overview, but if you have detailed questions about other processes, I might have to get back to you. So please feel free to email me with questions. Also, I want to sincerely thank you for participating in this training. I cannot tell you what a huge difference it makes in my work with clients when the interpreters are already familiar with court and the court system terminology. It really cuts down on the time and helps with the flow, which I find to be particularly important when working with survivors of intimate partner violence. They're already in positions where they feel very vulnerable. It can be difficult to establish trust. And so just having kind of an easy flow in the conversation helps so much. So thank you for participating. This slide gives an overview of the court system in Pennsylvania. Each state is structured a little bit differently. So this is specific to the Commonwealth of Pennsylvania. You'll see that we start at the bottom in terms of the police departments who might be responding to calls or making arrests. We'll then take defendants into the magisterial district judges, which are local neighborhood courts, or the Pittsburgh Municipal Court, which is downtown by the Allegheny County Jail. From there, cases can go up to the Court of Common Pleas, or if it's something in family or civil division, the cases might be starting there. Most of our work is centered in this lower half of the chart. Most of our litigants too, especially if they're represented by attorneys, this is really the only areas that they'll see. If their case is appealed, then their attorney would take up the appeal. It's only where there would be a pro se litigant, which is somebody who is not represented by an attorney, who might be making an appeal on their own or responding to one. From there, cases go to the Pennsylvania Supreme Court, and if appropriate, a case can be appealed to the United States Supreme Court. But I think one of the biggest misconceptions about our court systems in the US is that any case can go to the Supreme Court, and that's just not true. Okay. So we have the two different types of court cases. Civil court cases, which would include the protection orders that you can get in the family division as well as through civil courts. The caption of the case, which is the title basically of the case, we plaintiff versus defendant. The plaintiff is the one in a civil matter who initiates the case, moves it forward, or decides to. Okay. The criminal court side, the caption is the Commonwealth of Pennsylvania versus the defendant. It's important to note that the moving party here is not the victim or the plaintiff, it's instead Pennsylvania. The district attorney's office serves as the prosecutor, and the victim in this case would be a witness. So importantly, even if a victim decides not to proceed with a criminal matter, the state can still move forward based on other evidence. I think that's something that's, another common misconception. In addition to the caption, where you have either plaintiff versus defendant or the Commonwealth of Pennsylvania versus defendant, there's a docket number that's associated with the cases. In civil court, we've listed some examples of the types of cases that help victims of domestic violence: civil protection orders, which include a protection from abuse and protection from sexual violence or intimidation; custody, where parents are trying to get custody of their minor children; support, which can include spousal support and child support; and then divorce. In Pennsylvania, and certainly within Allegheny County, divorce is considered one count, and then you would have other counts as well, which can include alimony, equitable distribution, where you're looking at property, and these are all very intertwined for a lot of our clients, even though they are separate processes. I also think I forgot to mention at the beginning to please feel free to type in questions as I go, and I will ask for questions at the end as well. Okay. In terms of the civil protection orders, there are 3 types in Pennsylvania. Protection from abuse is the ones that I'll just tell you up front I'm the most familiar with. That's what our office works on. That's where the abuse is perpetrated by a family or household member. There are also sexual violence protection orders, where sexual violence is coming from someone who is not a family or household member. And then protection from intimidation orders, or PFI, where the intimidation is from someone who is not a family or household member. And importantly, this is where the perpetrator or abuser is over 18 and the victim is younger than 18. Okay. Under Pennsylvania's Protection from Abuse, or PFA Act, the PFA statute seeks to stop and prevent abuse between family or household members. Basically, they're looking at, has abuse occurred, or does the plaintiff have a reasonable fear of bodily injury? And then, is the abuse likely to continue moving forward? The enforcement of the safety provisions in PFA orders is criminal in nature. So if a client has, and we'll get into the different types in a minute, but a temporary order or a final PFA order, and one of the safety provisions is violated, then the enforcement of that would be criminal with mandatory arrest by the police, and criminal sanctions can include 6 months in jail and or a fine. The 2 main requirements to obtain a PFA order is the relationship between the victim and the abuser and the type of abuse. Not all types of intimate partner violence or domestic violence are covered, which I'll also address later. Okay. So the relationship between the victim and the abuser must be one of the following. In terms of family or household members, that's defined as spouses or persons who have been spouses, so an ex-husband, ex-wife, persons living as spouses or who have lived as spouses. So if somebody was dating, even whether a short time or long time, did they live together? Parents and children, and children and parents, it goes both ways, unfortunately. Other parent or other persons who are related by blood or marriage. So this can include examples such as You might have somebody coming as a victim who has been abused by their cousin's husband, for instance. Current or formal sexual or intimate partners. This is where we find the dating relationships, and there's case law to say that you don't have to have been dating long in order to seek a PFA order. And then persons who share biological parenthood. So siblings count. And I would say that note that the list doesn't include roommates, for instance, even though household members is there, it's defined just as you see here. So it doesn't cover every type of household relationship. Okay, and then the types of abuse required are listed here. There are 5 subsections in the PFA statute that cover the types of abuse. Attempted or actual bodily injury, serious bodily injury or sexual assault, conduct by the abuser placing the victim in reasonable fear of imminent serious bodily injury, false imprisonment, where you're holding someone against their will, physically or sexually abusing minor children, and stalking, which places the victim in reasonable fear of bodily injury. So importantly, the definition for stalking, which is knowingly engaging in a course of conduct or repeatedly committing acts toward another person, including following the person without proper authority, so not a police officer, for instance, acting in their duty, under circumstances which place the person in reasonable fear of bodily injury. You'll note that this does not include substantial emotional distress, which is something that's part of the criminal statute. That's a big distinction with PFA statute. So basically you're looking at conduct where there's on some level reasonable fear of bodily injury. Pre-pandemic and the judicial emergency as a result of the coronavirus pandemic, I would physically draw out a Venn diagram when I was meeting with clients, where in a larger rectangle, I would put all the types of abuse that one can suffer, such as emotional, verbal, psychological, mental, in addition to the physical. And then I draw a smaller circle for them that would be the PFA statute and the types of abuse that that covers. I think that's really important for victims and survivors to understand that the PFA unfortunately just doesn't cover all the different types of abuse that they've suffered. In terms of relief that is provided by the PFA Act, the defendant shall not abuse, harass, stalk, threaten, or attempt or threaten to use physical force against the plaintiff or anyone else that's protected under the order. The defendant would also be excluded and evicted from the plaintiff's home or residence, whether it's temporary or permanent, and that protection stays with them even if they move within that time period of the temporary or final PFA order. Defendants are also ordered to stay away from the victim's work that includes business or place of employment, school or daycare of children as well, unless there's a separate carve-out under the custody provisions. No contact with the victim or the minor children, again, unless there's a custody exception. And that would be direct or indirect, including through third parties by telephone or by any other means. So social media, text messaging, email, all of it. The PFA can also award temporary custody of minor children and address what that custody arrangement would look like. It prohibits defendants from possessing firearms for the duration of the order or other weapons. There can also be a temporary award of spousal or child support. You'll see in the Allegheny County orders that it specifies the plaintiff must then file for spousal or child support within about 2 weeks. So this would just be a very temporary form of relief. Damages for out-of-pocket losses, such as if there had been property damage or medical treatment that maybe wasn't covered by health insurance, or other relief to stop abuse. The PFA hearing system is divided into 3 different types of PFAs, 3 different levels. Those are the emergency, temporary, and then final hearing stages. They each occur at different places. So The emergency hearing can be sought from the magisterial district judge, and that would be any time that you're not able to file in family division, which is part of the Court of Common Pleas. This could be weekends or after, let's say, 11 a.m., Monday through Friday, or on court holidays. The emergency hearing is ex parte, meaning only the person who's filing is showing up and they're presenting their case, their reasons for seeking a protection order. It lasts until the end of the next business day when the Common Pleas Court Family Division is available. So if somebody seeks a emergency PFA on a Friday evening, let's say at 6 o'clock, that's going to remain in effect until the following Monday at 5. Or in the case of this coming weekend, for instance, where there's a court holiday this Monday, it would last until 5 o'clock on Tuesday. The relief that's available is no abuse, like I mentioned before, covering physical harassment, threats of physical abuse, no contact, and exclusion from the victim's home. So it can almost immediately evict somebody, possibly from the home that they share with their spouse or significant other, for instance. Whereas with the temporary hearing, those are filed in Allegheny County in the Family Division, the Court of Common Pleas on the 3rd floor. That is also ex parte, meaning only the victim or survivor is coming forward with the allegations. And by statute, that lasts up to 10 business days. No abuse and no stalking, no contact, exclusion again. Here they can include custody. So the court might award temporary primary custody to the parent who has sought protection. And then this is also where the weapons prohibition kicks in and where defendants could be required to turn over weapons that they have. Then within those 10 days, when the final hearing has been scheduled, that is also occurring at the Family Division Court of Common Pleas. And I just want to say, with the judicial emergency in effect, all of these are being held remotely. So if the plaintiff is represented by an attorney, then the attorney is the one reaching out to the defendant, whether the pro se or to their attorney, usually over the phone. And then when the case goes before a judge, if the case goes before a judge, it's through Microsoft Teams. The defendant must have been served in order for the proceeding to go forward that day. This means that they have the opportunity to participate. This is what distinguishes it from the prior two levels where only the victim had to be present in court. A final PFA is available for up to 3 years or can be any lesser amount of time. During the period of negotiation, prior to going to a hearing, a survivor can propose to settle the case a final order, for instance, that might only be a year or two. If the case goes before a judge, the judge then determines following a hearing whether or not a final PFA is granted at all, and if so, what that duration can be. And it can be any duration of time. It could be 30 days up to 3 years. 3 years is the statutory maximum. In addition to all of the types of relief that are available with the temporary PFA, there's also, like I mentioned before, the temporary child or spousal support, other damages, or other relief. Okay, just checking, I don't see any questions yet. Okay. Where there's a violation on a temporary or a final PFA order, then the victim can call the police, who are supposed to arrest for violations of the safety provisions of the PFA order. Those include the abuse provisions, the exclusion and eviction from the victim's residence, custody, the contact provision, the weapons prohibition, and the stalking or harassment provision. This is called an indirect criminal contempt charge. The arrest can be made without a warrant upon probable cause, which can include a plaintiff's credible statement, that's sufficient, whether or not the violation was committed in the presence of the police. So a lot of times now we're seeing cases where a defendant will continue to text a plaintiff. That's considered a violation of the contact provision, and they can be arrested and charged with indirect criminal contempt. The procedure is that the police would seize all firearms, other weapons or ammunition used during either that violation or during past incidents of abuse if they weren't already confiscated or, sorry, relinquished as part of the temporary PFA. The police take the defendant to the court or magisterial district judge where the contempt is alleged to have occurred for filing of the ICC charge and the preliminary arraignment. The hearing on the charge or complaint of the indirect criminal contempt, the ICC, is also to be held within 10 days of family court. Where there's been a violation of the temporary PFA, those dates don't always match up. So this sometimes leads to a situation where a PFA hearing might be continued so that both cases, the PFA and the ICC, can be heard on the same day. Other provisions within the PFA Act include no fees are to be charged to PFA plaintiffs. They are assessed on defendants, although there are a number of different ways, such as by consenting to a PFA that a defendant would then not have to pay those fees. Victims do not have to disclose their address if it would endanger them or their families. They can provide a mailing address where they can receive service of court documents and then list their address as confidential on the actual PFA petition and order. Addresses of domestic violence programs are not to be disclosed. So this comes up where a victim is staying in a shelter. They would check the box that their address is confidential. Communications between victims and domestic violence program advocates are confidential and privileged, and it is a statutory privilege similar to attorney-client privilege. The advocates come from a number of different agencies, including ours, Crisis Center North, Center for Victims. Basically, they're not attorneys, but they are legal advocates who are working with clients. They're not practicing attorneys, I should say. Confidential communications include communications made by or to a linguistic interpreter assisting the victim, counselor, or advocate in the course of their relationship. It's very important that this is explained to the clients. Ideally, the attorney or the advocate who is using the services of an interpreter would explain this and have the interpreter relay that information. Although I know I've worked with a number of interpreters who have an introduction that they use in all of their cases where they cover confidentiality. Okay, the Protection of Victims of Sexual Violence or Intimidation Act, known as PSVI, provides victims of sexual violence or intimidation a civil remedy that requires the offender to stay away from the victim regardless of whether the victim seeks criminal prosecution. It's similar to the PFA Act in terms of the different degrees that we're talking about, such as the emergency, temporary, or final level, but there are more limited types of relief, and they are only available if there is no family or household relationship between the victim and the offender. Otherwise, the PFA Act would kick in because it involves, with conduct, conduct includes sexual violence in the PFA Act. So examples of people who would not be a family or household member could be a roommate, a coworker, teacher, professor, or other sports coach, acquaintance. And in terms of relief, you only have two options. The defendant is ordered to have no contact with the plaintiff. That would include restraining the defendant from entering the plaintiff's residence, place of work, or school, and prohibiting the defendant from indirect contact with the plaintiff through third parties, and then any other appropriate relief sought by the plaintiff, which I realize is pretty broad. Okay. Orders under the PSVI Act are civil in nature, but violations are criminal like the PFA orders. Police can make warrantless arrests for ICC violations of the PSVI orders. If convicted of an ICC, then the criminal sanctions can include 6 months in jail or fines of $300 to $1,000 or other relief, such as continuing the level of protection, the protection order itself. In terms of requirements for the sexual violence order, Conduct includes sexual offenses, endangering the welfare of children where sexual contact is involved, corruption of minors, sexual abuse of children, unlawful contact with minor, and sexual exploitation of children. Again, keep in mind that this would be conduct between persons who are not family or household members. And the plaintiff has to show that they are at continued risk of harm from the defendant. So this would not just be a one-time event between strangers, for instance, although it could involve strangers assuming there's a continued risk of harm. The recourse otherwise would be through a criminal case. Okay, and in terms of the intimidation order, intimidation is conduct constituting a crime under the harassment or stalking criminal codes or criminal code. It's between persons, again, who are not family or household members. And importantly, for just the intimidation order, this is conduct that's perpetrated by someone who's over 18 against a victim who is younger than 18. The plaintiff, again, would show that they are at continued risk of harm from the defendant. So this is where, again, you might see like a sports coach or an adult friend of the family. Okay. As I mentioned at the very beginning, I think one of the things that separates interpreters in the court process from a number of other interpretation services that I work with, where interpreters may not be as familiar with the court system, is the terminology and comfort level with it. I realize that a lot of the people that we're working with are coming from civil law countries, whereas the US has a common law system. And so even amongst the states, there are a lot of different types of terminology, and the processes vary county to county within a state, let alone when you're talking about somebody from a different country with a completely different system. So we have some vocab words included on this slide. I'll go over some of them. Civil contempt could be where somebody has violated a portion of a PFA Act, for instance, that would not be a safety provision. So it's not going to be covered under the ICC that I talked about, but a civil contempt finding could still result in a fine, for instance. A continuance order occurs commonly with PFAs and really all types of court cases. That's where you postpone to a later date. This could be due to a lack of service, pending criminal charges in a related matter, for attorney preparation. If an attorney was just hired by, let's say, a defendant the night before their PFA hearing, and they need some time to prepare the case. Evidence would be documents or photos or other materials which help to corroborate one side's account of the events that are alleged to have taken place. Generations is the Family Division's children's court program that deals with custody. They conduct an education seminar, which currently, because of COVID, involves a booklet that parties are expected to read about co-parenting. There's a mediation session that would be just between the parties with no attorneys and a mediator, where they try to work out a custody agreement. And then also a conciliation with a domestic relations officer and or a hearing officer. The family court really emphasizes parties coming to an agreement because it's just better for them and it's better for the children, honestly, if they can work it out themselves. It's only after a number of different levels that something would then go to, a case would then go to a judicial conciliation, at least in the custody level. A judicial conciliation more generally is where a judge is going to meet with either the parties if they're not represented by counsel or with the attorneys. It's not a hearing, it's less formal than that, it's not on the record, but it's a chance for the two sides to get some insight or help from the judge to reach an agreement themselves without having to go through the formal hearing process. I know I've already said it a lot, but a PFA would be the abbreviation for the Protection from Abuse order. One of the options that I didn't discuss under the PFA portion was a non-PFA civil order, also referred to as a consent agreement or a no contact order. It's basically a contract between the two parties where you can include a lot of the same provisions that would be included in a final PFA. For instance, defendant shall not abuse, harass, stalk, or threaten, or attempt to use physical force against the plaintiff. the defendant is excluded from the plaintiff's home, no contact, prohibited from their workplace or the children's school. But then from there, you can kind of put in anything that the parties are going to agree to. You can still talk about return of property, which would be included in a final PFA, but maybe this is where somebody needs counseling for drug and alcohol or batter's intervention program. These things can be added to the consent agreement. The enforcement is different with those than a final PFA. There's no ICC charge for a violation. Violations are dealt with in other ways. Stalking I covered before. Supervised custody, there's a common misconception that the court can appoint someone to be a supervisor. Instead, the court has a human resources specialist who can refer clients to different agencies. There's also in Allegheny County a retired sheriff's deputy who started a program, and she can be hired as a supervisor. Or parties can agree to use somebody, maybe a family member or a mutual friend, who would then supervise one parent's custody time with the minor children. A hearing is more formal. The court hears testimony and renders a decision, or in the case where a hearing officer or a court's permanent master is conducting a hearing, they might make a recommendation that then goes to the judge. In Allegheny County, we have a one judge, one family system where the judge stays with the case, whether it's no matter what it includes, custody, support, divorce, PFA, you'll have the same, the one family will have the same judge. Safety planning is basically a way to help the victim or survivor with the next steps to mitigate ongoing risk posed by the abuser. We commonly say to our clients that the PFA is just one tool in their safety toolbox, that safety planning will get at other tools such as traveling different ways to and from work to kind of throw somebody off, putting locks on their doors, changing the locks on their doors, relocating if that's a possibility, those types of things. And I think I've covered all of those. Please let me know if I didn't. Okay, now we're going to move on to the criminal side. The caption, as I mentioned before, for a criminal proceeding is the Commonwealth of Pennsylvania versus the defendant. So again, it's not the victim who decides whether or not the case moves forward per se. It's the district attorney's office who's prosecuting the defendant. The victim is considered a witness for the prosecution and doesn't need a separate attorney. The standard of proof here is beyond a reasonable doubt, which is different to the civil side where they're looking at preponderance of the evidence, meaning more likely than not. So here it's a higher standard that's harder to meet. A criminal charge is filed when a section of the Pennsylvania Crimes Code is violated. Police will often consult with the district attorney's office before pursuing an arrest, for instance. Under the Pennsylvania Crimes Code, some examples of those that are commonly charged in cases of intimate partner violence would include simple assault, aggravated assault, basically everything you see here. I'm going to review these definitions on a later slide. Okay. The start of the criminal proceedings occurs when the police file the charges. Like I mentioned before, there could be a warrantless arrest, especially as part of an ICC, or where the officer can observe an injury to a person, or the police might need a warrant in order to arrest. The victims can also file the proceedings by filing a private criminal complaint. The local magistrates will have assistant district attorneys who come on different days and times. A victim can call to find out when the ADA is going to be there in order to talk to them about filing the criminal complaint. And that usually happens where the police, for one reason or another, won't file charges. Okay. I love this chart. I think one of the things that I found difficult when I first started here, since I don't work in criminal law, is knowing when exactly a victim has to participate. They'll call when I'm representing them in a PFA, for instance, and say, look, there's this formal arraignment coming up. Do I have to be there? And this chart is a great reference to just remind myself that for a formal arraignment, you don't. It breaks down the whole process. And as you can see, it looks like things are really spread out. Things happen very quickly initially with the investigation, and then a complaint being filed, the arrest, and the preliminary arraignment can all occur within 6 hours. It can be very quick, and then things start to slow down, where you might have 3 to 10 days before a preliminary hearing is scheduled. And honestly, especially with this pandemic, preliminary hearings can be continued for months, 9 months. It can be a very long time. And then from there, if the case is going to proceed because the Commonwealth has presented a prima facie case against the defendant, meaning they've shown that these facts, if proven true, could lead to a conviction, then it'll move to a formal arraignment in the Court of Common Pleas. From there, you have 3 to 4 weeks before a pretrial conference, 2 to 4 months until trial, and then another 60 days before sentencing. Again, all of these are subject to continuances, especially in the time of COVID. So when you look at this, it can really drag on for a while, let's say for a year. So it seems like things are spread out, but because of caseloads, especially in the district attorney's office or the public defender's office, I think for our clients, it feels like these things are moving really quickly. For instance, they might have notice of a preliminary hearing, but again, if they don't really understand if they're supposed to participate or not, they might receive a subpoena to testify shortly before. And because a lot of criminal cases can settle at different periods of this time frame, then they might find out, relatively last minute or while they're in the courtroom that they don't actually need to testify, as it turns out, because a deal has been reached, a plea has been entered. Okay. This is also, it goes to one of the areas where I'm just going to promote our legal advocates a little bit, where they're particularly helpful because they can get on the phone or in person explain what's going on to the clients who are already pretty escalated just emotionally because of everything going on. It's understandably intimidating to be in court in the first place. And then when you have people who know what they're doing and so they're talking really fast and flying through things, I think victims tend to feel quite lost during all of that. So the advocates can step in for emotional support and also to help explain what's happening and kind of break down the process for them. Okay. After a defendant is arrested, there's the preliminary arraignment at the magisterial district court level, where it's determined whether the defendant will be held in jail or released until the preliminary hearing and trial. Again, especially during COVID, there's a reluctance, I think, to house defendants in jail just because of the public safety risk, public health risk rather. But they do still consider the public safety risk in terms of, is this somebody who's particularly violent, where either bail is going to be set at a higher level, maybe like $10,000 or $25,000, or if they'll be jailed. So the defendant either remains in jail because they can't make whatever bail is set, or they could be released on bond or released on their own recognizance. The release on bond can be conditioned on no contact orders, which is just as strict as it sounds, or no violent contact orders, which would include abusive language, threats, etc. You'll see this especially where the parties might share kids, and so they're going to have some kind of communication. The victim can also importantly sign up for a jail release notification, which is very helpful in providing them an indication that their abuser is about to be released from jail, so they can either call their legal advocate to again safety plan, or can take a minute to enact their safety plan. Okay. In terms of outcomes at the pretrial proceeding, again, it could be postponed, and especially right now, a lot of cases are being continued liberally, I believe is the term that's used in the emergency orders. A plea is where the defendant could plead guilty, for instance, in exchange for charges being reduced or for a diversion program. I mentioned batterers intervention before. It could be a drug or alcohol program that they would have to complete, or the plea could be that they're saying that they're not guilty. Probation is where they'll have follow-up with a probation officer who will monitor whether the defendant is abiding by whatever conditions were set for probation. I mentioned counseling or batterers intervention program, such as, the counseling can be for drug and alcohol, for instance. It'd be a series of classes aimed at curbing the behaviors that led to the conduct in the first place. The defendant could be sentenced to jail, or the case or charges, individual counts, could be dismissed. Okay, in terms of the terminology used in criminal cases that are a little bit more geared towards domestic violence or intimate partner violence, aggravated assault is serious bodily injury under circumstances manifesting extreme indifference to the value of human life. This may or may not involve a weapon, and can also involve cases where the perpetrator is over 18 and the victim is a child who is under 13. So even if there wasn't a weapon and maybe the injury wasn't as grave as the serious bodily injury showing an extreme indifference to the value of human life, the age of the victim is important here. Whereas simple assault involves intentional, knowing, reckless, or even negligent conduct that could also include attempts by physical menace to put another in fear of imminent serious bodily injury, but can also include something like shoving, pushing or shoving that is unwanted by the victim. Postponement, again, we talked before, it'd be a continuance where the case is continued. The bail is the money that a defendant must pay to get out of jail. A bond, on the other hand, is posted on the defendant's behalf to secure release. So you'll hear those terms often used interchangeably. There is technically a difference, but again, they're used interchangeably. A formal arraignment occurs at the Court of Common Pleas. If you remember my favorite chart, the defendant gives or is given a copy of the information, which is the charging document. They are advised of their rights, and that's where they would enter a plea of guilty or not guilty. ROR, released on own recognizance, is a non-monetary bail. The defendant promises to appear at all future court dates, and then they're released. The preliminary arraignment occurs at that magisterial district judge level, where the defendant is read the charges against them, and then recklessly endangering another person, also known as REAP, is where a person recklessly engages in conduct which places or may place another person in danger of death or serious bodily injury. I believe that covers, and prosecution would be the district attorney's office who's prosecuting the crime. Prosecution can also just refer to the act of bringing somebody up on charges. So that concludes my portion. Are there any questions?
Sarah, there's one asking that if you are able to share the PowerPoint or like after the session.
I think so. That's a very good question that I didn't even think to consider. Let me just run it past the civil law project, but I believe I'll get back to you. If you could email me, I can go back to, oops, one second. Let me go back to that initial screen for a second that had my email address, but please feel free to email me about that then. Okay, are there any other questions?
You guys can just type them in the chat box.
Hi, Odise. I'm not going to pretend that the lack of questions is because that was completely thorough or anything. So again, please feel free to contact me if you think of anything later. And I also realized this was a very quick overview with a lot of information. So I encourage you to attend our other webinars and also to just seek out more information. I can speak for attorneys where I'll say, you know, we're very understanding when an interpreter wants to take a minute to quickly, you know, check the translation of a process and when they ask. Because it is important for all of us that our clients understand what's going on, especially with being in those heightened emotional situations. They're not always in a good place to hear what's being said, even if it's being relayed to them perfectly. And even if the attorney is or advocate is providing, you know, accurate, thorough information, they're just not in a place emotionally to always hear it and register it. So a lot of questions come up later again. So taking the time as an interpreter, but then also the attorney, I mean, you can point out if you feel like the attorney's just not getting it, maybe because there's a cultural issue. I'm thinking of a situation actually, Singh, I can't remember if you were in the room at the time, but involved a Mandarin speaker. And we were talking about the word facts.
Mhm.
And I was saying how it was no big deal to include on the PFA that you know, the defendant denies the allegations alleged in plaintiff's PFA petition because that's a fact. The defendant was saying, I didn't do this. But for the plaintiff, that held particular meaning, and she was very resistant to wanting that language included because of the connotation of truth that's part of facts. And the more I think about it, I think that holds true in English as well. But I can tell you from the attorney standpoint, where language like that doesn't have a legal impact and can sometimes help to get a consent agreement so that the victim does not have to be put through a hearing where they're going to have to then see their abuser, whether it's in person or during COVID times, see them on a screen, which in some ways can be worse because all of a sudden the defendant is right there in their face on their iPhone or on their computer screen. But I think understanding things, you know, either cultural or linguistic things, it's important that the English speaker understand that there is a reason why the client is maybe not understanding, or it's all of a sudden getting very upset, where it's just a matter of the difference in cultural language.
Yeah, I think in that case, I think I was there and we were able to finally understand why the victim was, it's hard for her to take that. But most of those cases, we rely on you interpreters to to see those cultural or language difference that we kind of cannot see that, and we need your help to let us know why and what are our clients are, you know, it's hard for them to move on with our suggestions. So we really need your help on that and your input on that as well. And Sarah, there's a question in the Q&A regarding to the weapon relinquishment.
Okay, sorry, having trouble getting my mouse to let me see the actual question.
Sure, it
Turning
says
it.
the interpreter did not realize the weapons needed to be surrendered.
If it's part of the order. So in a temporary PFA petition, for instance, there's a section where the victim would include, you know, have you ever been threatened? Has the defendant ever threatened you with a weapon or used a weapon against you? And then do you know or do you have reason to believe that the defendant possesses a firearm, other weapons, ammunition, and or a firearm license? And depending on what you check there, there's also a box then, well, actually it doesn't matter what you check there. There's a separate box for, are you requesting that the court order the defendant to relinquish weapons? If you check yes, there's a separate attachment called Attachment A, where you have to then detail what those weapons are, ideally in as much specificity as possible. So I mean, if you just say handgun, that's not going to help the police very much when they go to pick it up to tell the defendant what they believe. If the victim can say, you know, I don't actually know gun terminology, I shouldn't have gone this route, but a 33, you know, black semi-automatic, whatever, and then also where the location is. Is it under their bed? Is it likely to be on their person, in their car, in a safe, in the bedroom closet? There's a way for you to break that down. Then you also list on this attachment A, which is then signed by a judge, the police department's name, where the defendant is located, where they live, and then also the defendant's phone number. This law changed recently, I think it was just last year in 2019, that shortened the time frame for when a defendant is supposed to relinquish those weapons if that's been ordered, and it's now 24 hours. It also changed who they can relinquish it to. It can be their attorney if the attorney meets certain requirements, or the police, but it's no longer just, oh yeah, I gave it to my dad. Because what they were finding is, that didn't really do anything. That giving it to a friend, for instance, just meant that they could pick it up later, even if they had initially complied with that. And then at the final level too, that would either be another chance to request weapons relinquishment, or for whatever reason they weren't relinquished the first time, to do so. I'm going to be honest, practically speaking, it can be somewhat limiting or limited in that, the defendant could just say, well, I don't have that gun. And so without a search warrant, the police aren't going to be able to go into the house to then get it. But the idea of the law is to protect victims, because too often, even with getting the protection order, victims have been killed later.
Thanks, Sarah.
Thank you, Sarah. I believe there's one question in the chat talking about if you have any suggestions for interpreters how they can approach to attorney.
Sorry, how they can approach the attorney?
Yes.
So they thank you.
Oh, for how to approach.
Yeah, so they thank you for linguistic
Yes.
needs of interpreters, and they're asking how you approach.
Yeah, feel free to ask in more detail if I'm not hitting this, because I kind of interpret that in two ways. One would be, just logistically, if you're interpreting through the court, for instance, the court administration is going to provide us, the attorneys, with your contact information, and will then reach out to you typically that day, depending on when you've been hired for that case. So something like, around 9 o'clock in the morning on a PFA. And then the other part of that would be, in terms of just more on a personal level, how to approach the attorney when you are then talking to them. I think just being open, introducing yourself, and then I think it depends on the degree to which the attorney is familiar with and comfortable with working with interpreters. I'm by no means perfect in this regard, but I do try to give an introduction to the interpreter, to give them a sense of the case, and especially any language that might be uncommon for them. This is particularly true where the interpreter is not a court certified interpreter. So they might want to take a minute to look up custody. Conciliation is a word that I'm finding does not translate well in a lot of languages. It just doesn't exist, it seems. So, having a chance before you join the client in, to have that conversation. So I think you're perfectly within your rights to just say, hey, can we just take a minute beforehand to kind of go over what we're going to be discussing? And if you have an attorney who, to be honest, is a jerk and balks at that, then you're in for a difficult time. And then so use whatever interpersonal skills you have. But otherwise, I think attorneys really appreciate the help of interpreters, and so they should be willing to slow down and to work with you on that. I also try to lay out some ground rules with clients in the beginning, where I'll say, I'm going to ask the interpreter to interrupt either one of us if we're going on too long and they need a break. I think it's important that I understand exactly what you're saying, and so please speak in short sentences and just 1-2 sentences at a time. I'll wait, I'll pause to make sure that you finished before I then interject. If you have an attorney who's not giving that introduction, please feel free to suggest it to the attorney. Again, I just think it helps overall with kind of establishing the relationship amongst all the parties if either the attorney or the interpreter takes the lead in telling the client what to expect, because inevitably in almost every PFA case in particular, because whatever's happened is just so recent and so raw, victims will just start going. Or from the attorney side, we're so used to saying, okay, this is the procedure, this is what's going to happen today, that we forget to pause or to slow down. So I would say in terms of your approach, just kind of lay out from the beginning, like, hey, is it okay if I interrupt you if I need a minute? Or to explain, that you're taking notes, whatever you need so that you feel more comfortable.
Yeah, I think, so I was an interpreter before I started this job, and I have been a interpreter for federal court hearings. And what I do was I will send email to the court staff who schedule the interpreters, and I will have like a list, like a document, to a letter to the attorneys, to both parties, to ask the court staff to send the letter to the attorneys before the hearing date. So just to lay out the foundation, how you feel comfortable to proceed working with an interpreter. What are your tips for the attorneys to work with you on that case? And I believe, as Sarah mentioned, always feel free to talk and ask the attorney. And I believe most of the attorneys are really welcome you to approach to them. And I think some of you might encounter some attorneys are not, like, they're just so busy and they don't give you the time to communicate. Please don't take it personally. Probably they just have too much on their hand, and probably they don't have the experience working with interpreters. They don't know they need to give the time for the interpreter to communicate, and that actually helps them moving forward during the process. So just feel free to ask and just let them know, try your best. And I think I believe most of the attorneys will accept your help and are welcome your help and communication.
All right, is there any other questions from anyone? Thank you, Sarah and Singh, for chiming in.
Yeah, let me just share last screen again.
All right.
I agree. I saw one comment, I think it was from Joan, that you wish that attorneys knew that, they have to slow down or be interrupted, and I agree. But again, feel free to bring that up to them.
And so this year we break down all the our annual interpreter training into different webinar sessions, and it's on every Wednesday afternoon from 3 to 4 p.m. And the next coming up webinar would be next week, October 14th. And we really hope that we can see you again. And please feel free to invite your friends or anyone that you know would be interested to attend and benefit from our webinars and are interested to be an interpreter or who are already an interpreter working with clients. Is there any more coming from the chat? Or...
Nope, just a thank you.
All right.
Thanks, Adise.
I also put in the survey, if you guys don't mind taking a minute to give us some feedback on how we did today. And like Singh said, please attend the next one. I will be one of the hosts for next time as well. So we really look forward to seeing you guys.
And I believe next Wednesday would be me presenting with my colleague, Natalia.
Okay.
So we really thank you for joining us. And if you have any more questions, like Sarah said, you can email her for more following up questions. And we welcome your feedback. Please fill out the survey to help us to improve. And we will see you next time, next Wednesday. Thank you, everyone.
Thank you, everyone.
Sorry. So for some reason, the link for the survey isn't working. Don't worry, there will be a follow-up email with the link in it as well. So we apologize for that. Thank you, everyone, for attending. We really appreciate it.